Yes, but just be prepared to turn it off again. I'm just, and it's nothing against you, Mr. Nielsen, it's just, I don't want people talking about things that a potential juror could be watching on Facebook or YouTube and then fail to tell us about it when we get to jury selection.
I'm not really sure I understand. Judge, we've got a, Judge, I think we've got a negotiated plea here.
Okay.
The plea agreement's kind of a hot mess, but case that I didn't include, had to write that one in, and going back and forth and make changes. So in the terms of the changes, it's 100 hours community service work, and the state objects to him being able to have contact with the victim regardless of her consent. This is one where the victim had asked for charges to be dismissed, but and it's the one that we've got the motion to dismiss filed on the trafficking and paraphernalia. But Mr. Bell made a counteroffer of 8 months probation, and the state
8 years
has accepted
probation.
it, or 8 years probation, and the state has accepted it with these terms and conditions. I've run it past Mr. Bell, and Mr. Bell wants to accept that.
All right. Ms. Leone, is this yours?
Yes, it is.
So it would be aggravated stalking, trafficking, and possession of a firearm by convicted felon.
Not trafficking, Your Honor.
No,
That's
Judge.
what it's listed as trafficking.
Judge, count, under 699, count 2 only, which is the possession of firearm, ammo, or weapon by a convicted felon, and that will be as constructive possession. So no mandatory minimum. The trafficking and the paraphernalia would go away. If you look at the bold
We'll be
face.
dismissing completely the trafficking count.
Yes, Your Honor, the FDLE came back negative for fentanyl, so I couldn't go forward.
So it wasn't actually fentanyl.
Right.
No, it was not.
Okay. And those are the kind of things I like to understand as to
Absolutely,
why
yes.
it goes
Your Honor.
from several minimum mandatory sentences to dismissals.
Yes, sir, and I
And I think you
on-
indicated this before, Mr. Williams, but I just don't, always put the cases back together in my head until you tell me again, so I appreciate the state advising of that.
Yes, sir. You should see it, though, on the plea agreement where it says FDLE report stated no drugs per Chapter 893.
Oh, now I see you. As you said, you gave your opinion on what the plea offer looks like at this point after you fixed it.
Yes, sir. Yes, sir.
Okay.
I agree.
All right, this is what you want to do, Mr. Bell? It's going to be 8 years of probation? And it's a downward departure still?
Yes, for a need for treatment and uncoerced plea and request of the victim.
All right, Mr. Bell, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
Can you state your full name and date of birth?
Area Marquez Bell, 08/11/1996.
Okay, and Mr. Bell, you're here on 3 separate cases, and I'm going to go through what you're currently charged with. You can put your hand down, Mr. Bell. 25 CF 698, aggravated stalking and use of a two-way communication device to facilitate a felony. And then you've got 25 CF 699, trafficking in fentanyl. That's the case that the state was going to dismiss because it wasn't actually fentanyl, according to the FDLE lab report. possession of a weapon or ammunition by a convicted felon, and possession of drug paraphernalia. And you also have 25 CF 1095, burglary, unoccupied dwelling, grand theft, and criminal mischief misdemeanor. Do you understand all those current charges? All right, I want to go through the plea offer before you accept it, obviously, but just to make sure we're all on the same page. My understanding is on the 699 case, you'd be pleading only to the possession of a firearm, ammunition, or weapon by a convicted felon, which is a second-degree felony and punishable by up to 15 years in state prison. And the state would be dismissing the trafficking and the paraphernalia. In the 1095 case, it would just be the grand theft and the criminal mischief. Is that right?
Yes, Judge.
And then you'd be pleading as charged in the 698 case, which is the aggravated stalking and unlawful use of a three-way communication device, or it should be two-way, shouldn't it? Are those all the counts that you expect to plead to, Mr. Bell? Okay. And my understanding is that the main portion, which is the possession of the weapon or ammunition, is going to be adjudication of guilt, 8 years probation, 100 hours of community service, substance abuse evaluation, any recommended treatment or compliance with the ECLC program, no contact with the victim, no trespass at her residence, maintain employment or 5 applications for jobs per week and 8 hours of community service per week, $515 in court costs. And the 698, it would be 5 years probation concurrent with $967 in court costs, also batter's intervention program. And then the 1095 case, it would be adjudication 5 years probation concurrent on the felony counts, reserved jurisdiction for restitution for 90.
Yes, sir, on the criminal mischief.
For 90 days and $515 in court costs there. The misdemeanor cases, which is, I think that's just the criminal mischief, right?
It should be just the criminal mischief. That's all.
At this point, it is
Yes, sir.
just time served.
Yes, sir.
Is that what you're looking to do, Mr.
Yes, sir.
Bell? All right, have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it? It took me a while to get through all that. I just want to make sure, that's why I went through it kind of slowly with you, so that we can make sure everyone understands what's being done here. My next question was going to be, have you signed it? Mr. Williams. I know a lot of it's changed today, so
Yes, sir.
I just want to make sure that it's done that way.
Thank you, sir, if you signed it right there, if that's what you want to do. And today is November 3rd, 11/3/25. Thank you.
Thank you, sir. All right, now you've signed the agreement. Yes?
Yes, sir.
Okay. And are you satisfied with your attorney's advice?
Yes, sir.
Have you, are you under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea?
Sir.
Has anyone promised you anything in return for your plea?
Sir.
You understand that by entering a plea, there won't be a trial of any kind, and that you're giving up your trial rights, which are on page 2 of the agreement that you've now signed. And you understand you're waiving any potential defenses that you may have.
Yes, sir.
And do you understand that if you're not a U.S. citizen, you could be deported from this case? Let me just make sure again. What is your plea in 25 CF 698 is to 1 count aggravated stalking and 1 count of unlawful use of a two-way communication device?
No contest.
No cause.
No contest. In the 25 CF 699 case, what is your plea to the possession of a firearm, ammunition, or weapon by convicted felon?
No contest.
No contest.
Okay. And just for the record as well, Ms. Leone, is the state agreeing that's a constructive possession, or was it not a firearm?
It was a firearm, and the state agrees to constructive possession.
Okay. And that just allows for it to not be a minimum mandatory when the state does that. And in 1095, what is your plea to the grand theft and the criminal mischief?
No contest.
No contest. I'm going to accept your no contest pleas as freely, voluntarily, knowingly given. In the 699 case, does the state have announcements as to the 699 trafficking and paraphernalia?
Yes, the state dismisses those 2 counts.
Okay, and then the 1095, the burglary?
The state dismisses the burglary.
Oh, hold on a second. Was that? Actually, it doesn't say that on here. Was the agreement to dismiss the burglary?
Judge, we certainly don't have any objections.
No, but it was, Your Honor.
Okay. All right, burglary is dismissed by the state as well. Sorry, I'm just trying to piece it together from what we've got here. All right, so as to the 699 case, count 2, going to be 8 years probation, adjudication of guilt, 100 hours of community service. You're to do a substance abuse evaluation and any recommended treatment or comply with the Emerald Coast Life Center program. No contact with the victim, no trespass at a residence, maintain employment, or if you're not employed, 5 job applications per week and 8 hours of community service per week, $515 in court costs. In the 698 case, in counts 1 and 2, will be adjudication of guilt, 5 years of probation for each count. They'll be concurrent with the 699 case. Special condition batterers intervention program and $967 in court costs. In the 1095 case, be adjudication of guilt on both counts. On the felony count, be 5 years of probation concurrent with the other felony counts. Reserve jurisdiction restitution for a period of 90 days. Another $515 in court costs. The misdemeanor case will be time served. That's the criminal mischief count. Also, $50 application fee and 3 separate $100 PD fees. Waive cost of supervision due to the fact he's represented by the Public Defender's Office and has been found to be indigent. This is a downward departure based on the uncoerced plea bargain between the state and Mr. Bell. Also, the need for treatment and the victim's request. Although I don't think that's enumerated in 921.0026. It's being put into the record. All right, anything that I've missed on Mr. Bell?
No, Your Honor.
Oh, the stalking case has additional costs, so that's the 698 case. 867? I had 967. Well,
No, ma'am, that was based on an older form that I was looking at.
okay. 867, not 967, so it's $100 less in court costs. Anything else?
Not on this case, Judge.
Okay, so Mr. Bell, I need you to speak with probation since you're going on probation. Then I need you to be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court.
Thank you, Judge.
All right, thank you.
Judge, I've spoken again with Ms. Casper. She has some counteroffers she'd like me to run past the state. I've not had a chance to do that, but Ms. Casper is not in a position where she's going to be getting out. And so I'm just going to move to continue it. It was set today for plea or continuance. This is the lady that we had the medical furlough on.
We had one already.
We had one, yes, sir.
Right.
I'm fine to continue, Your Honor.
All right, but it's getting old too. It's a year and a half.
Yes, sir. I do not think it's likely to be a trial. I think it's just trying to figure out the logistics and get a plea agreement that everybody will agree to.
Ms. Casper, I'm going to put you on December 23rd at 1 o'clock for your next pretrial conference.
Judge, you said 12:23 at 1. Do you mean 12:23 at 9?
You're right, 9
Okay.
o'clock. We probably won't get to everyone by 1 o'clock, but
Yes, sir.
Thank you.
I hope we can go faster that day than normal, but
Judge, this is Marcus Hamilton. He was passed from VOPs for today. This is a VOP case. Judge, he's asked me to make another counteroffer to the state. Judge, if the court will set it on even as early as, I'd prefer to do it on Friday, since I've got that situation with my daughter I told the court about before. I made arrangements for somebody to look after her on Friday so that I can do the state's motion and eliminate hearing.
I don't have any cases on Friday.
You have a case on
I
Friday?
don't have any cases on
You
Friday.
don't?
No.
Do you have anything on Thursday then? And
I will be your Thursday.
All right, I'll figure something out, Judge.
Thursday at 2 o'clock, right? Because the morning is, Special
Mr.
701
Hamilton,
case.
I cannot ask for a bond for you today.
I know, I
Okay.
said what Thursday's for. So
Okay, I'll try to get something drafted up for you like I told you I would.
I
Okay?
was asking if that was what Thursday was. I didn't hear.
No, Thursday is to bring this back in to see if we can get it resolved. But I'll go ahead and I'll draft up a bond
Yes, sir.
bond motion before I leave today.
Yes, sir.
And make sure that it gets filed for you, okay?
Yes, sir.
Okay.
11/6 at 2 o'clock.
I'll see you on Thursday,
Yeah,
okay?
yes, sir.
You, Mr. Jones?
Yes, sir.
Okay. Judge, we've got a negotiated plea on Mr. Jones's case. It's going to be a plea to a misdemeanor. Mr. Jones, have I gone over the agreement with you? Okay. This is the one that we talked about for resisting. This is the one that I brought out to the jail and talked with you about yesterday, plea to resisting for 6 months county jail with credit for time served.
Yep.
Okay. Get your signature there. Thank you, sir. Mind if I date it for you? Is it okay if I date it for you?
Sir,
Okay. And I'm sorry, sir, it's been a long day for me too. If you need more time to talk with me or something like that, I can pass it.
No, that's good.
I apologize if I seem like
No, you're
I'm
good.
stressed today.
Thank you. Mr. Jones, if you could raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
yes, Your Honor.
You say your full name and date of birth, please.
Howard Blake Jones, 05/04/1987.
And Mr. Jones, you're here on 25 CF 1398. I've been handed a plea in the sentencing agreement that calls for you to plead to a lesser included charge of resisting without violence for adjudication, 6 months county jail, time served, $270 in court costs, and a $100 PD fee. I'll give you some time to pay that once you get out.
Thank you, Your Honor.
Is that what you want to do today?
Yes, sir.
All right. Did you go over this plea and sentencing agreement with your lawyer?
You what, Your Honor?
Did you go over the plea agreement
Yes,
with your
sir.
lawyer?
Yes, Your Honor.
And did you understand and sign it?
Yes, Your Honor.
And are you satisfied with your lawyer's advice?
Yes, Your Honor.
Are you currently suffering from any mental health issues?
No, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No, Your Honor.
And do you understand by entering a plea there won't be a trial? You understand by entering a plea there won't be a trial? So I moved away from the microphone like I always tell
understand.
people not to do. All right, and so you understand you're giving up your trial rights, which are on page 1 and 2 of the agreement you've signed? And do you understand that you're waiving any potential defenses you may have? And do you understand that if you're not a U.S. citizen, that this could lead to your deportation? All right, and what is your plea to the lesser included offense of resisting without violence?
No
Yes, Your Honor.
contest.
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given to the resisting without violence, adjudicate you guilty, 6 months county jail, credit for time served, $270 in court costs, $100 PD fee. I'll give you 60 days from the day you get out of jail to sign up for either a payment plan or pay those costs.
Your Honor, when I'm done here, I have a hold somewhere else. I'm going somewhere else. So I'm not going to be able to pay that within 60 days.
I'm going to put it to judgment, Mr. Williams.
Yes, sir.
All right, it'll just go to judgment. You can get out and pay it and get rid of the judgment. But since I don't know where you're going and how long you'll be there and anything else, I don't want to make it even harder for
Okay.
you.
Thank you.
All right. I don't need probation. I don't need fingerprints. So you have 30 days to appeal, Mr. Jones. Thank you very much.
That'll do it.
Land.
Judge, this is Mr. Land. It's going to be a plea to probation with a condition that he successfully enter and complete the FORS drug treatment program, but the state wants it bars to bed. The only wrinkle that came up when I was talking with him is he's got a hold from
Mobile.
Mobile. Yeah, he's gonna be going over to Alabama when we finish up with him here. So I'm not sure whether that means they're gonna transport him back here or Fords would have to pick him up from Alabama, or how exactly that's gonna work. And I've got it as 2 years. I think what you and I had talked about was 3 years. But he was wondering if you go along with 2 on the period of probation.
No, I'll do 3 years.
3?
Yeah.
Let me make a suggestion, since it looks like I'm going to be back here either Thursday or Friday anyway, or both. Let me find out whether or not the Forge is going to pick him up from someplace, so that we have that. I already emailed my investigator asking him. I just haven't heard anything back from him. I emailed him on it this morning. And maybe bring him back Thursday or Friday. I'm going to, I guess, say Thursday now.
Are you going to be here Friday?
Judge, I think I'm going to have to be, but I'm going to want to do that and get out and relieve who's going to look after.
You don't have to talk about your personal things on the record, Mr. Williams. I know what you're talking about. I'm not trying to tell you to stop talking.
I understand, Judge.
Mr. Williams.
Yeah.
Okay.
Can't resolve this now, like, I get a certain amount of time to report to the program and call, or however that, I mean, I'm just ready to get this resolved so I can get on and I'm just ready to.
I understand. First of all, it's going to be 3 years probation.
That's fine.
Ma'am, would you agree to a report time, a schedule, once he gets released?
Yes,
report?
yes, as a condition of probation, so if he doesn't, then he
Right.
violates.
Thank you.
All right, so
That way we can,
change this all again to 3 years. I'll initial it. Let me get you to initial it,
where at?
just anywhere up in here. Okay. And how long do you want to give him to report?
24 hours from release.
right, you understand that, sir?
I do.
It's 24 hours to get to the program?
Yes, sir.
What if the program doesn't have a bed at that point?
I don't
I'm
know
reading
what
Mr.
to,
Barry's mind for the first time today.
I don't know what to tell you, Judge. They have accepted him. We have an acceptance letter. And
I don't know if
how
it's
they're-
gonna be a week from now or a year from now that he, that he gets over there because he's gotta go somewhere else and we don't know what's gonna happen there,
Yes, sir.
especially because it's another state.
I am completely open to suggestions.
When is that 3 years probation supposed to start too, if he's gonna be in jail in another state? I know I've got all the bad questions, but they have to be answered.
Well, Judge, my position is he's sentenced today, so it would start unless the court ordered otherwise. Order that be told until he's released from his Alabama sentence.
I mean, I think that's the only fair way to do it, isn't it? I mean, how does someone get to serve a jail sentence and probation at the same time in different jurisdictions, different states?
Yes, sir.
I mean, obviously, if he gets out and does the program and is doing superb, he can always move for early termination, but I just don't want to be a situation, I mean, what if the circumstances that, I don't know, Mr. Land, I'm certainly not trying to make this sound terrible for you. I don't know what Mobile's gonna be for you. Is it something minor, or is it something you might go to
So,
prison for a couple of years?
I have a private attorney there, and he told me, because that's what we had spoke about, was me getting a program here,
Okay.
and that they would just follow suit over there. So, I mean, whether that happens or not, I mean, he seemed pretty confident that that would happen. So, I mean, as soon as they came and got me, I would probably get into court rather quickly, being that it's a private attorney. So, I mean, I'm open to whatever, because I'm
just trying to figure out some logistics before we're trying to fix it on the, later on.
understood.
All right, what I would say is it would toll until he gets out and can start his program.
Yes, sir.
Otherwise, we just
Fair.
don't know. I'm not saying you're trying to deceive the court in any way, Mr. Land, by any means, but I just want to make sure we know what's going on over there for sure before we do that.
Understood, but that would be I would be able to get an early termination provided I complete
I'm not
the
saying you
program.
100% will.
No,
I'm saying you can always
right.
apply.
I would have that option yes, okay.
Everyone has the option to file a motion for early termination, whether they're
Okay.
granted or not. I don't know. And, the other thing I always say is, I'm not always going to be the judge in this chair.
Right.
So I don't like to lock in anybody else into some sort of requirement just because I was the one that was here when you pled. For the same reason, I would hope I wouldn't be, have my hands tied by a prior court. All right. We ready, Mr. Williams?
Yes, sir, I believe we are. Sir, I need to get your signature there, though. Okay. Mind if I date that for you?
Yes, sir.
No, I see. It's just that with the line there, I think.
I moved this one up here.
Oh,
But I should write it.
draw an arrow or something.
No, it's okay.
Thank you. Where is the Forge program?
Vidalia, Georgia.
Another state.
Yeah, I'm relocating. My father moved to Georgia, and I want
I'm not being critical, Mr. Lane. It's great that you're getting treatment. My concern is you're about to enter a plea to go on probation in Florida. Then you're going to be transported to Alabama to handle your case there. Then you're going to go to a treatment center in Georgia, all while being on probation in Florida. Mr. Berry, does,
Look, just to call me Mike.
okay. You've taught me well over the past 20 years or so, Mr. Berry, that I'm seeing these things before you tell them about me.
I'm even trying to figure it out myself as I'm sitting here.
Well, my concern is once he gets released from Mobile, if he's going directly to Georgia, then he's never kind of past go in Florida, so to speak. And then,
Have to come here for us to initiate a transfer. Treatment alone is not grounds for a transfer through the interstate compact system. And they would probably come back and tell us there's plenty of places in Florida.
Well, from his point of view, though, that would not be a willful violation of the supervision if he's not able to because of our rules or Georgia's refusal to accept him.
but we also can't set it up to fail.
Yes, sir. So I don't have any solutions to offer.
That's not.
Mr. Land, if you were going to another jail or something like that in Georgia, that's one thing. You don't have any choice. But even if I sentence you to probation with the condition that you go to Georgia to do that treatment, the interstate compact, which is the agreement between states that they can supervise our probationers who live there and vice versa, has to have certain reason as to why it's been being done. Otherwise, Georgia will say, well, we don't want them here. And if they say that and they don't supervise you, now you're in another state not being supervised. Like I said, probation has been teaching this stuff to me for about 20 years since I was a baby lawyer appearing in these courtrooms.
So I wouldn't, so you're saying that they can just say that we don't want him in our state, period, because he's on
They don't want to
probation?
supervise you in their state. Because if you're in another state, you have to be supervised by a probation officer there, and if they refuse to do it, then you'd have to come back here. And maybe you're not in willful violation of your probation because you can't control that. We're back to square one. As you see, what I've been trying to do this entire time is fix these issues on the front end and then instead of trying to fix them later.
The Forge, no, I mean, I had to do a phone interview with the Forge, and they knew that I was incarcerated in Florida when I did this.
That's not the issue, Mr. Lane. It's not, can you go to the program? We're allowing that. That's part of the probation. But if you get to Georgia and they say, we're not supervising him because we didn't approve this.
The state of
then now-
Georgia.
The
Right.
state of Georgia, their probation department, then you're up in another state not being supervised. And I understand you're in a program, but even if it were a lockdown program, I still think that's a problem. And this is not my decision. This is how the states work through their departments. I mean, the Department of Corrections is a part of the executive branch. I don't control them.
Okay. So if that were to I mean, say that you were to agree to this and that were to happen, I get there and they say, I mean, at that point, would I be able to come to Okaloosa County and get into a program here? Or the reason I know too many people. I'm 44 years old and I'm tired of this right here. I'm tired of being, and I'm just tired of the life that I've chose to live. And
I understand, Mr. Lane. I think it's a great thing for you to, number one, get treatment, but two, have the insight to understand that you need it. Those are great things. That's part of what the system's trying to do. My problem is, again, I can't tell Florida Department of Corrections how to handle it, let alone Georgia's Department of Corrections or probation. Again, it's a, I don't really want to go down this rabbit hole, but it's kind of a big misconception that somehow the judge can control everybody who appears in their courtroom. I can't tell the state attorney how to handle things. I can't tell the defense lawyers how to handle things. I can't tell DOC to handle things. It's just, my position is to make sure that cases are being resolved, and according to the law. But I don't want to be in a situation where you get thrown in this limbo, and next thing you know, you're back here trying to figure it all out again. I also don't like the idea of, kind of crossing our fingers and hope it works, because that's, again, that now we're getting back into my role on not giving people sentences that they can't potentially accomplish what they're supposed to.
You wouldn't give me an allotted amount of time to,
Can I
May I,
try to, oh, go ahead.
It may
You
resolve.
may have a solution.
I would be agreeable to withdraw the requirement of bars to bed, put a condition that he needs to report to Okaloosa County as soon as within 24 hours of his release from any
Yeah.
other incarceration, and then from here, he can apply for the residential facility.
Well, anticipating what I think the judge is going to say, what if he doesn't get accepted someplace, no place has a bed available?
Put an alternative that he has to do a substance abuse evaluation and treatment.
I think that will work. That is in keeping with what the procedure would be anyway. The procedure would be you get released over in Alabama, you come here, you meet with probation here, and then they coordinate things from there.
okay. And that would be a possibility, the forge, if they go along, if Georgia goes along with that, that would be acceptable? Is that what you're saying?
Yeah, I don't think anybody's caring what you do to accomplish the change.
Got you, okay.
Just understand, this is not a negotiation that I'm part of. What I'm just saying is I don't want to set it up where it can't work. That's kind of what my role is in the situation. Mr. Berry? what are you-
Your Honor, probation's gonna tell, Mr. Land that there's a ton of places in Florida. Find you one in Florida and you won't have to worry about Georgia, Alabama, anywhere else.
I understand that there's probably 1,000 programs in Florida, and I know that, you know what I mean? But like I said, my family has relocated to Vidalia, Georgia, and that's the only reason that because I was informed about this program, and it's supposed to be a very good program, and like I said, I'm trying to get out of Florida due to the fact of I know a lot of people here, and I'm ready for a whole new start, you know what I mean? So that's kind of where I'm at on that.
Why don't we do this at this point? Why don't we take a pause, see if y'all can work something out that works with probation where you're not going to end up in again, I'm just trying not to get you jammed up and back here and trying to figure it out when someone says, you're not allowed to leave Florida. And then you're like, well, I've already set this up, and it's going to be, sorry about it, is the response you may get. Then you got to come back here. We're going to try and figure out how we can modify your probation in a way that'll work for you. But again, I don't want you to do that without any notice of it, and then you're stuck in Florida. You got to find a place to live. You got to find a place to go to do your treatment. So I just want to figure it out now before we.
Right.
I kind of use this more in juvenile things, but all we can do is the best we can as we push that paper boat into the water. I can't control it once it's out there unless it comes back to me. And then it comes back to me usually on a violation or needs a need for a modification, then we're just kind of starting over again.
So we'll just go along with me reporting here and finding a program?
If that's what you want to do, or if you want to try to brainstorm amongst everybody and figure it out. I just don't want to spend too much more time on it right now so we can resolve other cases while that's going on, and then we can bring you back later this afternoon. It's just, we're getting to the point, I'd like to get everybody out of the courtroom by 5 o'clock today because I've held them here hostage 3 out of 5 days last week past 5 o'clock.
Well, I think that'll work. I mean, I report to Okaloosa County, and if,
I don't think I'm going to pass your case so y'all can figure out an actual plan that's going to work. And then I'll readdress it. But I'm not going to go around in circles about it right now until we get, again, you've got a wealth of knowledge in the people you're talking to, but I shouldn't be a part of the process on figuring out how it's going to work best. I'll certainly accept it once it's figured out, but we'll bring you back up later today if they can figure it out, Mr. Land.
I thought that's what we had just talked about, like.
I understand what you're saying. I thought we did too, but I'll talk with Mr. Berry and Ms. Leone, and.
I mean, if it takes 5 minutes of communicating, you huddle up in the corner right now, we're going to accept it right after that.
Okay.
Because it seems like every time we figure something out, someone else figures out a way that's not going to work, including me, including Mr. Berry. I just want it to work for you, Mr. Land. I'm not trying to jam you up I'm trying to do the exact opposite of that. I know maybe it doesn't feel like that right now because I'm the one that's pumping the brakes, but trust me, I've seen these things fall apart afterwards, and it's trying to re-put your whole life and your probation back together on the fly with not knowing where you might be putting your head down on a pillow at night. That's what I'm trying to avoid for you, because you're looking to get the treatment. You've got the insight, you want the treatment. You want to change your life. This whole, I want to go to Georgia because I know too many people here. That's what you're going to hear about, people, places, things. That's what you need to change to get out of this lifestyle. I agree with that. I just want it to work. All right, we'll call you back up. Just let's figure that out, why we handle some other cases.
Judge, the last case that I have is Andrew McDonald. I've been advised by, well, let me see. Okay. I went out to the jail and spoke with Mr. McDonald for between 2.5 and 3 hours yesterday. And I guess he heard that I saw some other people this afternoon and didn't ask to see him because I'd already gone over things in great detail with him yesterday, that he's refusing to come out unless I go talk with him again.
All right, so do you want to go do that?
Sure.
That'll be great.
Thank you, Judge.
Judge, if I might, can I ask what your next cycle dates will be for trial?
You're not on the microphone. I won't be picked up.
Yeah.
Mr. Cobb, you're talking about what case?
Cordell Thomas, he wants to know what the next cycle court dates would be, because he may agree to a continuance for me to depose this witness, but he wants to know what those dates are.
Pre-trial would be December 23rd. And then I believe I've got. Then the docket day would be January 5th, jury review January 9th, and the trial weeks would be the weeks of the 12th and 20th, the 20th being a 4-day week. That's why they're 8 days apart.
Thank you, Your Honor.
All right. Thank you. Mr. Maddox, are you?
Yeah, I'm ready. Yes, Your Honor.
If you change your mind, let me know.
Sorry about myself.
This is Ms. Ash, Your Honor. She was continued from the pretrial detention hearing. She was taken for medical attention. If you'll recall, Your Honor, 25
I forgot that last part until you just told me. I was trying to remember why we didn't finish it last week.
Yes, Your Honor. The state and I have had the benefit of reviewing her mental health evaluation report, Your Honor. The state and I have also had the benefit of further discussing this, and we have reached a bond given the court finds it acceptable. Your Honor, we're going to go with the recommendations in the report in terms of mental health pretrial services and all the terms described there, Your Honor. So it'd be accessing psychiatric appointment for medication management, take all medications as prescribed, and comply with all recommended treatment. No contact with the victim, standard conditions of staying away from the victim, Your Honor. My client has agreed to wear a GPS monitor. It'll be a $5,000 cash professional bond, and then mental health pretrial services with those terms I just went over, Your Honor. Did I miss anything?
No, those are the terms
All
we
right.
agreed upon.
So this is a case we had from last week where the state wasn't seeking pretrial detention in the case. We just had to determine a bond. Had mental health involved, and then she had a physical health concern while she was here last week when we were trying to get it done.
Yes, Your Honor.
All right, based on the agreement, it'll be a $5,000 cash or professional bond on mental health pretrial supervision. Ms. Ash, you're going to have to go to the psychiatric appointment for medication management, take all medications as prescribed, comply with all recommended treatment, no contact with the alleged victim in the case. Don't be within 500 feet of his home, his vehicle, his job, or any place that he frequents. You understand that? Was there something else I missed?
GPS monitor.
GPS
attached,
monitor. I
Your
knew you
Honor.
added something at the
Per
end.
agreement.
GPS monitor at $1 per day.
They have to charge $1 per day. It's
Will
the-
you pay, you,
She was asking how to pay, Your Honor.
Pretrial services will explain it to you. You're going to have to meet with them before you get out. So they're going to have to put the monitor on you, which may not be today. So you might not get out till tomorrow, but you'll talk to someone from pretrial supervision. All
Good
right.
thing.
Thank you, Ms. Ash. I'm going to hold on to that for now.
Oh, and then for the benefit of the court's knowledge and the state's knowledge, I am going to have her evaluated for competency, Your Honor, and I've discussed that with Ms. Ash.
Okay.
Mr. Carpenter? Carpenter? Richard Carpenter? There's Carpenter. I could have a brief moment, Your Honor?
Time's up. I just realized that Mr. Cordell Thomas' other case is also still on the docket under Mr. Maddox, so let's just make sure. I cover that when they bring it by. I forget to. Just tell me.
Your Honor, this is Mr. Richard Carpenter before the court in 25 CF 1405. The state has made an offer contingent on him getting into some sort of treatment program, Your Honor. Project Hope may have accepted him. Mr. Carpenter thought he may have been accepted into that program. I've reached out to them, Your Honor. They are unable to get with me until November 7th. They'll be back in the morning. I contacted one of their representatives. I plan on speaking with him before court Friday morning, and I've already coordinated that with him, Your Honor, to get a confirmation letter of Mr. Carpenter if he has in fact been accepted into the program. If he hasn't, Your Honor, it'll be a plea or continuance type situation, but like I said, Mr. Carpenter thought he might have gotten into that program, so if he did, then I just need the acceptance letter to provide to the state. If we could put him on the 7th, Your Honor?
That's fine, Your Honor.
The 7th is turning into like its own miscellaneous date at this point.
And I apologize.
And it's fine. I just want to make sure that, we're not going to be here till 6 o'clock on a Friday now, too. And again, I'm here all the time. I just don't like keeping everybody else here all the time.
I would
Your
put it
client
on.
appears to have a question or a comment.
Yep.
All right, 11-7 for plea or continue.
All right.
All right, 9 o'clock.
Or, again, I'll take recommendations from the court on another date. If, I know we don't usually put too many cases
Well, if it's a
on there.
situation that resolves the case and allows him to get into a program, I don't want to delay that because remember, I don't have anything for a couple of weeks after Friday because it's the trial period.
Yes, Your Honor. If I figure out anything and am able to take him off, if we don't have any sort of firm resolution, I'll certainly inform the court.
Your client is raising his hand again.
Yes, sir. All right, go ahead. Your Honor, he wants to talk to the court about what he wants to address. I've spoken to him about it, but I can't stop him from
I
addressing the
just want to
court.
make sure you understand, Mr. Carpenter, that everything in this room is recorded. The prosecutor in your case is going to sit here and listen to you. If you talk about the facts of your case, that can be used against you. They can play a copy of the video recording and audio recording of this at your trial. So I'd be very careful about anything you talk about. I'm not going to ask you any questions, even if what you tell me triggers some questions, because I don't want to be seen as trying to require information out of you.
Sir,
Go ahead.
I was charged with the same case, 1405, December 11, 22, done 1129 on VOP. My 2 first degrees was dismissed, and that was given.
I don't understand. You were charged with this same case in 2022?
It was a 1405, yes, sir. December 11th.
Your Honor, I've discussed it with him. I don't believe he's correct about this at all, but
The offense date for this case is July 9th, 2025.
Okay,
Separate
so you
case.
weren't charged in 2022 for something that happened in July of '25. All right, thank you, Mr. Carpenter.
Yes, sir.
We'll see you on Friday.
All right, sir.
Thank you, Ms. Leone. I was trying to look it up, but you beat me to it. Who's this?
This is Mr. Frazier, Your Honor, Terry Frazier, before the court in 25 CF 1018. Your Honor, we've reached a resolution, just need to get Mr. Frazier's signature.
Okay.
Gee, man. There you go, sir. And they are gonna, yes, sir.
Steve on vacation
As far as the release,
Sir? May I approach, Your Honor?
Yes, sir.
He was just asking me about the GPS. I'm wanting that we're gonna get it attached tomorrow, should be released tomorrow.
All right, Mr. Frazier, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
yes, sir.
Can you give me your full name and date of birth, please?
Harry Wayne Frazier, sir, 11/17/1985, sir.
All right, Mr. Frazier, you're here on 25 CF 1018 on a violation of probation. I have a plea and sentencing agreement on that. That would, if you admit your violation, modify your probation, converting the entirety of that probationary term to community control, $100 VOP fee, $100 cost of defense. You'd have to complete and abide by the original terms of your probation. Also, a GPS monitor will be attached at $1 per day. I believe that's everything. Is that the state's agreement?
It is, Judge.
Any issues with that, Mr. Berry?
No, no, sir.
No, he's asking for it,
And
yep.
and it's to be attached prior to release.
Okay, and that was in my head because Mr. Maddox had already said it, but I didn't say it. So once that GPS monitor is attached, you can be released, but that's probably going to be tomorrow at this point. Do you understand that?
Yes, sir. That's why I was just trying to figure out so that way I can let my fiance know.
Yeah, I understand. I just want to make sure it's clear because it wasn't written,
Yes, sir.
that portion. Oh, so the GPS monitor will be on during the entire community control? You
Yes, sir.
understand that?
Yes,
All right, Mr. Frazier, did you go over this plea agreement with your lawyer?
yes, sir.
Did you understand and sign it?
Yes, sir.
You satisfied with your lawyer's advice?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering any mental health issues?
No, sir.
Is anyone forcing you to do this?
No, sir.
Is anyone promising you anything in return for this plea?
No, sir.
You understand if you admit your violation, there won't be a hearing where the state would have to prove how you violated?
Yes, sir.
Okay, and do you understand you're waiving any potential defenses to your VOP?
Yes, sir.
All right. And what is your plea to the violation of probation? Are you admitting or denying that?
Admitted.
All right.
Is
I'm
what
going to accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, modify your probation to convert the entirety of it to community control. You'll have a GPS monitor during that entire time at $1 per day is the cheapest they do it. $100 VOP fee, $100 cost of defense. Complete and abide by your original terms and conditions of your probation. This is a downward departure. The reason for that?
It's based on a legitimate uncoerced plea. We would note it's the defendant's first violation on a failure to register when he has 90 priors. And the basis was working past his permit time in Walton County. Probation did note also that he's been compliant otherwise.
All right, anything else for Mr. Frazier?
No, Your Honor, thank you.
All right, I'm going to have you go talk to probation.
Yes, sir.
Was he convicted on the underlying?
He was, Your Honor, previously
Yes.
adjudicated.
Just want to make sure I don't need the fingerprints. I'd assume so, but,
Thank you, Your Honor.
all right.
You You're not sure what the situation is with that. Did she have a misdemeanor? I don't know. I'll look back. Several cases here, Your Honor. She did indicate that she wanted to plead. That's why she's on this docket. I don't think we have anything worked out sufficiently definite, Your Honor. Certainly we'll work on that. I would ask for a continuance to the December cycle, Your Honor.
All right, December 23rd, 9 o'clock.
And then, Your Honor, was there, I know we have Thomas. Do we need to address him again?
And Your Honor, I don't have any further business. If I could excuse.
Yes.
Thank you.
Judge Jason Cobb on behalf of Cordell Thomas again. We're still in a position where Mr. Thomas is desirous to go to trial. I've explained to Mr. Thomas the need to depose the witness. Let me finish, and then we'll deal with it. But if he wants to waive that, and he wants to say he understands, I want the time to depose the witness now and the time for trial, then we can keep this up and do it. He also understands and knows that murder case I'm getting ready for, but I'm a big boy. I can do both at the same time. I don't want to put this off any longer for Mr. Thomas. If he wants to go to trial on this case and he understands I will not have time to depose the witness, then we can do it.
And Your Honor, I have to correct what I said earlier about the minimum mandatory. I verified the drug analysis report, and he's facing a 7-year minimum mandatory. It's 46 grams of methamphetamines.
All right, so the plea offer was 60 months, but it's a 72-month minimum mandatory.
Yeah, yes, that is correct, Your Honor.
The state's offer would also include the other case.
It will include the other case, yes.
Just because we talked about it, I want to make sure it's out there as
Yes, yes.
corrected.
Yes.
Mr. Cobb, do you know when that other case would actually be going to trial? Would this be a one-day trial?
Excluding jury selection, yes. I would ask though for the second week.
I'm trying to see if I could shoehorn into that Friday like we talked about, but.
I'm gonna make it work.
All right, Mr. Thomas, do you understand what you're asking to do as far as go to trial when your lawyer's saying he hasn't deposed what could be an important witness in your case?
Yeah, I told him that's fine. I just told him that's fine. If he wanted to oppose him, well, that's cool.
Well, what he's saying is he doesn't have the time to do that before the trial period starts.
My schedule, I wouldn't be able to get that arranged between now and, 2 weeks from now? 2.5, 3 weeks from now?
Well, it would be the week of, well, it'd be 2 weeks from today.
Yeah.
So,
Of course, Your Honor, you know, I have trial next week, so I won't be able to do it next week for sure.
Would there, it'd
So
be-
just so you know, when a witness is being deposed, the state attorney is supposed to be there too. And she's already in a trial that's going to go most of next week.
For the record, I've explained to Mr. Thomas the best that I can explain to him that I wouldn't be asking for a continuance just to delay it. I'm asking for a continuance because I believe sincerely it's in his best interest in the overall outcome of this case. Whether or not he decides to go to trial, it's imperative that I do have this officer on the record so that I can use that record to possibly cross-examine him at trial. I've tried to explain that to him, and so we're talking about a difference of a trial in 2 weeks or a trial the second week of January. 2.5 months difference. And I'm asking for the 2.5 months. And I know it's going to be Thanksgiving, Christmas, and that's the problem, but in the whole long term of things, it'd be in his best interest to allow me to depose this witness.
I think you've explained that, Mr. Cobb, and that's your advice, and he doesn't want to, I'm not saying he doesn't want to take your advice, he disagrees and wants to do what's right for him, in his mind.
you want to depose the officer, that's fine. If it's for my best interest, that's fine.
What he's saying is he can't do it before trial this cycle.
So it'll be continued till,
If you want him to depose him, it'd have to be continued for that purpose.
And I'll set that as a firm, fast, no more continuances. Of course, I know there's things happening. But I will gear up and have it ready to go that time. Yeah, I've explained it to him. It's up to him, Judge.
Well, you keep saying that's fine, Mr. Thomas, but what is fine? Continue the case for the deposition or
Yes,
go to
sir.
trial?
Yes, sir.
Mr. Thomas, it's really getting frustrating when you just talk instead of listening. Is it fine that you want to go forward with the trial without having to pose this officer? Or is it fine that you want the case to be continued to give your attorney enough time to depose that officer?
It's fine that I will have the case continue, give my attorney enough time to depose the officer.
I just asked also, as far as his other case, he's got a bond on that case he could make, right?
No, I don't think, I'd have to
Does
relook at it, Your Honor. Let me just check. So
Okay. I'm just trying to make sure if there'd be a situation, even if you went to trial, that even if you were acquitted on this trial, that you'd still be sitting in jail waiting for your other case now. But what I don't want to be in a situation is we push kind of case A back, which then pushes B back, and then every time it's a continuance, it's almost like a 4-month continuance for the other case.
Yes, Your Honor, and the state and I have discussed this case pretty extensively. We may be able to come to some sort of resolution with Mr. Thomas would take, but the state and I are still working on that. The state has not made a firm decision one way or the other.
Okay.
On the counteroffer that I made.
That's fine.
Does he have a bond in that case?
That's what I'm looking at now.
Because I believe he bonded out in my case and then got rearrested.
It's $500.
Yeah, he has a bond, Your
He
Honor.
does. He does, Your Honor. He has a $5,000 cash professional bond on the false imprisonment charge and a $1,000 cash professional bond.
That's what I was looking at too, so I'm just trying to figure it out.
I believe his original bond in my case was revoked.
It was, once he got the new charge. Again, this is before your time, before my time, on the cases.
Sure. Your Honor, can I ask?
Can I have a second? Talk to Mr.
All right, anything else? All right, so we're going to put it on to 12/23 at 9 o'clock. Trial will be continued to depose the witness. I would heavily suggest y'all coordinate that deposition as soon as possible so we know for sure it's done before we get back to court. All right. And I would like to have it completed before we get back there, not just set. I know it's a tough time of year to do it, especially with y'all having trials, but I would guess it's not a very long deposition.
Get it set. I'll
All right.
contact the JA this afternoon. Well, sorry, it already is this afternoon.
Not the
Not the
JA,
JA, I mean her assistant, yeah.
Yeah, my assistant doesn't set that up.
Yeah, no, I'm not going to contact her.
Your Honor,
Appreciate it. Yes,
excuse me,
Mr. Thomas.
between time, I will be able to like put in, like he said, put in a motion for like to give me a bond or something.
Yeah, I told him I'd file a
between
motion.
time?
You can certainly do, I don't remember if you've had a bond motion before, since it got revoked. So I don't want to make any comments on whether or not you can or not. It's just whether or not there's a substantial change in circumstances since the bond was set. I mean, it was revoked because of the new case. But again, I don't think we've ever addressed it as far as I know, but I just have to make sure it wasn't addressed in front of my predecessor.
Told him I would if I could.
All right. All right, thank you, Mr. Thomas. Now I'll continue his other case as well.
Judge, I believe that's all I have. Madam Clerk, there's nothing else? Okay, thank you.
All right, so we're going to see you Friday for Strahan, right? Okay.
I'll be up to see you as well, Mr. Thomas. Judge, just real quick, were you able to review Ms. Ulrich's papers?
I did.
Okay.
What else was I going to do during lunchtime?
I just didn't want to forget to grab it.
It looks like it was actually filed. I don't know if she sent it to the clerk's office because it's in the court file.
Oh, that's good.
All right, thanks.
Judge, this is Andrew McDonald, 2025 CF 1192. He's got 2 other violation of probation cases tracking along with it. Judge, we were set for today to discuss what discovery had been received, what additional discovery was needed. I did file a motion to compel in the case. One of the things that I had mentioned in the motion to compel, though, was the witness statement. I did find the witness statement. I do have that. But went up to the jail, went over everything with Mr. McDonald, spent about 3 hours. And I got up there, left shortly before 3 to go to the jail and from the office. And left at 6 p.m. on the dot. We had a good discussion, I think a cordial discussion. But Mr. McDonald asked to speak to me a few minutes ago. He's a little nervous talking with the court, feels like maybe he doesn't do real well when he's trying to explain himself. But the short version is, despite everything, he just doesn't feel comfortable with me representing him in the case. He would like to have me removed. He was a little bit concerned as to whether or not I would be offended by all that. I informed him that I was not. One bit of information I did discover looking through everything, or a couple of bits of information, is that the conflict with Charles Hall of our office was based on a Nelson inquiry. Looking through the file, there was a Nelson inquiry dealing with lack of contact involving Mr. Hall. RCC was appointed on that case. Tell me who the RCC guy is again that's got your... Scott Klein. Scott Klein's. So it'd still be Mr. Klein's, Judge, if you did have us withdraw on it.
You're free to withdraw or not potentially, Mr. Williams, if that's what you think. We can discuss that. But otherwise, if it's a Nelson inquiry, I have to understand what his claims are first.
Well, Judge, I don't think I have, as an appointed attorney on the case, I don't think I have the ability to simply withdraw.
As soon as it came out of my mouth, I don't think I said it the way I intended. You can ask to withdraw, but I have to make a decision on it. He can ask for have someone replace you during a Nelson inquiry, but I don't know what the situation is at this point.
Yes, sir. The only thing I think I could say or help I could give is it may be a situation where for Mr. McDonald, the relationship has broken down sufficiently that he's just not comfortable with my representation. I don't think he's claiming that I've done anything improper anymore. As far as the motion to compel, I did go over that with him. We very nearly made a decision to simply withdraw it. But I think what made it very nearly was concern, and I base this on a question that he'd asked me, over the continuing obligation to provide Brady material. And so you understand that even if we don't have the motion to compel, that they still have to provide all that stuff. That's just part of the Brady material's a federal constitutional right, or a federal prosecutorial obligation. So
I don't understand the motion to compel. It seems pretty almost boilerplate, I would call it. Is there anything specifically you're asking?
At this point, I'd love to get CAD reports, but I really think that that's the biggest thing that I'm missing on it so far. After talking with him about it, doesn't sound like anything occurred subsequent that's going to create a problem. My next step in the case, frankly, is just to depose the alleged victim in the case, see what she has to say. There were no other witnesses to the event. So I think that it would all rise and fall on her.
I mean, are you able to get a CAD report from the case?
While we were in court last week, I was able to get the whole report with, I didn't know you also needed the CAD. I'm gonna get the CAD.
We'll have everything. Obviously, if she can't get it or doesn't provide it, I'm sure she will once she has it.
Yes, sir. Yes, sir. And that's what I was trying to explain to Mr. McDonald, is that these obligations are continuing. And we brought it to everybody's attention, so I don't think we necessarily need to worry about it too much. I've got the information that I need to question the alleged victim in the case and get her scheduled for a deposition. But I'm gathering from looking at his expression that he's still just not happy with having me on the case.
Well, Mr. McDonald, you're going to have to explain to me what he's done that's been ineffective or what he's failed to do for you before I can consider just appointing you a new lawyer. Saying, I haven't heard from you anything yet, but he says, you're uncomfortable. You are uncomfortable with him, but I would need to know why. If you're going to do that now, I'm going to have to ask you to raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, go ahead, Mr. Can you push that microphone over?
Yes, sir.
Because he's,
Sir, it would go back to the same thing, prior history. Also,
prior history of what?
he's represented me in a criminal case before now. You told me you didn't want to hear about that. You only want to hear about this case. So in this case, he told me in front of you that he would be out to see me. You said he only had 5 days. 2 months went by, I've come back to court. Still hadn't seen him. Everything that I read for Florida Bar, and I'm not a very good speaker, and I'm the studying law I've not done. So, but from what I can see, there's a duty for attorneys to have some sort of attorney-client loyalty to one another, and I feel like that relationship's broken down when he told me right here, recorded in court, that he would be to see me and did not come. You even addressed
What was that you're referring to?
During the Nelson hearing.
At the arraignment judge, I tell almost everybody I'll be out to see him after I have discovery. In our conversation last night, he informed me that that's what I had said to him, and I explained to him that that's why we were having the argument we were having with the state in court, was that I didn't have discovery.
His discovery exhibit was done on August 15th.
Judge, that was a discovery exhibit, just listed witnesses' names. As I explained to the court before, we were having an issue where they were filing, we would call them complaining we didn't have discovery. They would file an exhibit, but then they would file it with just the first appearance paperwork and not anything that was actually useful in the case. Other than the arrest.
August 20th, there was a amended discovery exhibit with the digital evidence. Did you receive that?
I did receive the digital evidence, but I didn't have other reports I referenced when I was in front of the judge, and the reports that the state just indicated they gave to me later that day.
Incident report was given over on the 30th. Filed the motion compel yesterday. Have you seen him in the jail?
Yes, I was out in the jail again. I saw him initially before his arraignment. I went out to the jail to see him again after I got the incident report and was no longer in court for arraignments, BOPs, and hearings. Went out and spent 3 hours with him yesterday.
So he
On a Sunday.
does come to see me at the jail. He has no information sheet. He tells me as soon as I get a discovery, I'll be back.
What is an information sheet?
Information sheet concerning what I'm even there for. Other than
Charging document, Judge, the information.
same thing Charles Hall told me on another case. He didn't have no information. But Mr. Williams says that he'll come see me when he gets.
Didn't you come to arraignment?
He did come to arraignment, Judge, and the state did file an information.
Don't they give you a copy of it at arraignment?
I believe that they would have, Judge, but
Are you saying you didn't see it then, Mr. McDonald?
No, no, sir. He told me too that he would be to see me when he got to the discovery. So I filed the Nelson hearing. When I get in here with you, you tell me that he's only had it for approximately a week. He says right here that he'd be to see me. He never comes and sees me. I come back in here Friday. We were in here last Friday or Thursday? Wednesday. And he still hadn't come to see me, even at that point.
But I'm reading your correspondence, your Nelson inquiry, where you state counsel has in the past shown incompetence and total lack of regard in the accused cases into which he failed in the overall circumstances of the accused interest, and that the accused alleges a conflict of interest specifically with other members of the accused family. Talk about how they assign cases alphabetically, which is how pretty much every state attorney's office and public defender's office that I've ever been associated with, worked at, or dealt with in court. Is how they do it. The court-appointed counsel may not apply his skill to the fullest accord.
Yes, sir. And I based that off of being in the ECLC program. I was asking for him to advocate for me in that case.
Advocate for you in what case?
In the case where I've been in ECLC, I've been asking him to talk to.
What case are you in ECLC?
One that I got the VOP for, sir. Like now, I'm currently in ECLC again, and I've got approved for Phoenix House. I'm trying to get treatment, sir. I'm only trying to fight for recovery. I want to stay in recovery, sir.
I understand.
Fella tells you he's going to do something, he doesn't do it. How do you trust the next possible 25 years of your life?
You just spent 3 hours with him yesterday.
you know, I will point out, Judge, I showed him the videos and the photographs in the current case. That was one reason why the interview took so long.
Most of this motion for compel, most of it seems like he's pretty much had all that footage that he's asking for.
That's what he's saying. He has it now, so he's going to basically withdraw the motion and compel because he has everything. The state is still, as he's stated, under an obligation to continue to send things over as they get them or become aware of them. Is there something specific you think hasn't been turned over?
Sir, I'm not stating that at all. That's not to me in question. The effectiveness of representation and avocation is what I'm concerned with, sir.
But you haven't given me any reason other than he didn't come to see you as soon as you wanted, but he spent 3 hours with you yesterday.
Not as soon as 60 days isn't sufficient enough time, sir, for him to come see me. He said in court to you and me that he was going to come see me after he had that discovery, and he didn't. I came into court before he came and see me, sir. And then you told him that he needed to put in a motion compel. You're giving him instructions on how to do his job, sir. I don't mean no disrespect, sir, whatsoever.
Well, the problem, Mr. McDonald, is I'm not telling him what to do. But what I'm saying in court is if you don't have something you need, feel free to file a motion to compel. I say it all the time because I don't want to be in a situation where we're here not getting anything done because things haven't been turned over. I tell lawyers all the time, and it goes back to my days as a lawyer, you should file motions all the time about motions to compel, Brady violations, Richardson hearings about discovery issues, even things where you think maybe evidence was not properly preserved or destroyed. It's Arizona versus Youngblood. You can file those motions, and we'll set them for hearing. But it's not enough to just come into court and say we're missing something, which is why he filed the motion to compel. But now he has everything except for maybe a CAD report, which the state doesn't have in their actual possession, but we'll get it and turn it over. Anything else, Mr. McDonald?
I would like to just represent myself, sir.
All right, well, then we can do a Ferretta hearing, but we're not going to do it today.
Fine, sir.
All right. All right, we'll set that for December 4th at 2 o'clock.
Is that for the
For the Ferretta.
Thank you.
And the case will be put on December 23rd for pretrial. You the last person? Mr. Land? Did y'all figure anything else out?
Quickly, Your Honor, did we do the 22 date for Ms. Orr? Is that the date that? or you wanna do 12?
If you want to come up to the microphone, I mean, make sure you pick it back up. My reading of what you supplied on Ms. Ulrich's case is that there's, in that packet was saying she can go back to work on October 28th.
I thought it said sorry, Your Honor, yeah, it did mention she could go back to work. It also recommended bed rest and that
It
sort of
didn't
thing,
mention
Your Honor.
bed rest, it said rest at home.
I just don't
I don't think I've ever been to a doctor with a complaint where they didn't say you should rest at home. The letter they gave specifically excused her for work for a particular day, but then said she can go back to work on October 28th. I'd like to also point out, at the last pretrial, we continued it to October 27th, and I told you that was the last continuance.
That's correct, you did.
And so now here we are with, an ER visit, where the doctor or whoever from the hospital said she can go back to work the following day, and we still haven't seen her a week later.
Well, Your Honor, I thought it was implied that, forgive me if I misunderstood the court, but I thought it was implied she did not need to be present today based on the conversations that were had at the pretrial
Are you in contact with her?
Yes, Your Honor, I am.
Get her here Friday.
I will.
But someone go into the emergency room on the day of a court date where I told them it was last continuance, and they say you can go back to work tomorrow. It's not going to be sufficient to just miss court and continue the case for another couple of months after. I mean, if I let people circumvent my orders like that, then we're never going to get a case done.
Court's position's understood, Your Honor. I'll make sure to reach out to her and make sure she's present on the 7th. Clear trial situation, then I assume, Your Honor?
Well, she's not set for trial at this point, is she?
No, okay. Well, no.
I mean, it's somewhat accomplished, maybe what was intended, I don't know. But, I need her to show up.
She'll be here.
Okay, and it's going to be a trial the next time around.
That, understood.
See you on Friday.
Yes, Your Honor.